Okay, anytime.
Good morning, Your Honors. May it please the court, my name is Andrew Bose, and I represent the petitioner in this matter, JPMorgan Chase Bank N.A. or Chase. Chase is not a party to the foreclosure matter below. It's instead a non-party that was subpoenaed for deposition in the case. The plaintiff below, which is U.S. Bank as trustee, is seeking to enforce a promissory note that the respondent and borrower, Mr. Lofgren, made out to Washington Mutual Bank about 19 years ago, back in 2003. Where Chase comes into this is the record shows, excuse me, the record shows that Chase possessed this note and loan from the time that Washington Mutual closed in 2008 until 2014. There's an assignment of the note and mortgage from the FDIC as receiver of Washington Mutual Bank, assigning the note and mortgage to Chase. Then Chase assigned the note and mortgage to a trust in 2014, and then that trust transferred the note to the current plaintiff, who then brought this foreclosure.
And if I may, Mr. Bose, let me see, because the facts are laid out beautifully in the brief. So let me see if I could get to the heart of the issue here. First of all, there's no question that this is a first-tier cert proceeding. You agree with that? And
I do, Your Honor.
all right. And if I understand your argument in the brief, is basically you're taking the issue that the order allows, quote, carte blanche irrelevant discovery, and based on that would warrant certiorari relief under, I think you made reference to Lance and its progeny. And if I'm not mistaken, you're not alleging any type of privilege. You haven't alleged any trade secret. You haven't alleged any privacy interests that are issue. You're simply taking the position that this discovery is irrelevant because of the issues raised in the complaint. Am I understanding your position correctly?
The position, Your Honor, is that the discovery order allows discovery into a particular topic. It's a very broad, vague discovery that is all about an endorsement and in support of an affirmative defense that wants to challenge that endorsement. We cite to two reasons why this respondent has no ability to question that endorsement at all, and why the trial court does not have jurisdiction to consider a challenge to that.
But you're not a party to the litigation. So essentially you are asserting, I don't know, defenses to the suit?
No, we are asserting what, and I'll quote what this court said in Root v. Balfour, which is that a quote order that entitles a party to carte blanche discovery of irrelevant material demonstrates the type of irreparable harm that may be remedied via petition for writ of certiorari.
And I understand that, Mr. Bose.
But you know,
You're trying to say, as I read your briefs, you're basically taking the position that as a matter of law, because this is a cert proceeding, in order to be entitled to cert relief, that as a matter of law, that this discovery cannot ever reasonably lead to the discovery of other relevant information. That's how I understand your position, that as a matter of law, even though this is a cert, even though we haven't had discovery based on the limited record before us, that this is what you're asking us to do. Am I wrong? And I think that's how you present it.
No, that's correct. That this discovery order authorizes, as you said, Your Honor, carte blanche, irrelevant discovery, matters that are, as a matter of law, irrelevant, that this respondent does not have a substantive right to raise.
There's a big difference, Mr. Bose, between irrelevant and what you have argued, which is a lack of standing and lack of subject matter jurisdiction, versus, you know, their assertion that the endorsement was invalid. And if if the lawsuit raises the invalidity of that endorsement, why isn't the inquiry of your client relevant to that question?
Because the respondent who's seeking this discovery does not have standing, does not have a.
I just already acknowledged that you are arguing things other than essentially the relevance of the inquiry. You're asserting basically affirmative defenses to the suit, and you're not a party to the suit.
Well, what I would say is, if the only thing that his discovery seeks information about is something that could never be relevant, that no one has standing to challenge, that he does not have standing to challenge, it's necessarily categorically irrelevant. And that's the first. The second is that the challenge to that endorsement, that the court doesn't have subject matter to consider that at all under the under FARIA, Your Honor. And that's basically a federal statute, and that's the statute that gave the FDIC its powers as receiver. It's a very all-encompassing statute, and it keeps essentially everything related to an asset or an institution that goes into receivership in-house under that statute.
And I'm trying to, I guess I'm trying to understand, Mr. Bose, if you're making reference to FARIA, I guess I'm trying to understand, how can you contend that basically the court have a jurisdiction of an action, but then not have jurisdiction of a defense to that action? This is what you're suggesting. And so this is what I'm having a hard time with your proposition.
Well, with respect to that FARIA argument, Your Honor, yes, the court can have jurisdiction to an action because the elements to someone enforcing a promissory note, that they're in default, that they receive notice, the amounts due, they can question their standing. But it's different when the subpoena and what they're seeking to question actually challenges a determination of rights with respect to that based on some action or omission that Washington Mutual took when it was under receivership. And that is what
I guess that circles back to my first initial question, that you're basically taking the position that based on this limited record before us, that cert needs to be granted. In order for cert to be granted, as a matter of law, we will now hold that this type of defense is totally irrelevant, that every single one of these foreclosure cases, if that defense is raised as a matter of law, it's totally irrelevant. And I think we would be the very first case that would ever come out to say that.
It would be the first.
Beyond that, you're suggesting that we can, on the basis of a certiorari petition by a non-party, declare that the defendant's affirmative defense is invalid on cert.
Yes,
and,
Your Honor.
And the plaintiff in that lawsuit is not in front of us as a party.
Yeah, yes, Your Honor. And it's because this is, as a non-party who will have no right on appeal, an order compelling production of documents, an order compelling a non-party to appear, as this court says, is reviewable by certiorari because he or she has no adequate remedy. I have no other.
But the question is whether you have a remedy that, based on the fact that they have asserted what you contend is an invalid affirmative defense, and I question whether on cert we can even consider whether that's any of your business.
Well,
as Judge Kazam has pointed out, you haven't asserted any sort of privilege. You haven't, you're going to the merits of the underlying claim, and I'm not sure that's really an appropriate scope of our review under this cert.
Well, if the question, Your Honor, is whether there is an irreparable harm, carte blanche, irrelevant discovery, this court holds is irreparable harm. So the court can find that that's irrelevant. And
it's a case law, though, that if you were a party, you wouldn't be able to get a cert to avoid doing what you consider to be irrelevant discovery. I mean, the alleged irrelevance of this discovery. I mean, there's case after case after case that says that is not cert worthy. So why should you, as a non-party, be entitled to a greater right to cert than a party would be?
Well, the one case that I cite to Your Honor, which is Root versus Balfour, it does say that in addition to privacy rights, an order that entitles a party to carte blanche irrelevant discovery is.
Why is this carte blanche a relevant discovery?
Excuse me, Your Honor?
Why is this carte blanche? Isn't there a particular area of inquiry? They're looking to see what happened to discover the circumstances of the Washington Mutual assignment.
It is extremely broad discovery into one topic that, as a matter of law, this respondent cannot raise. And that is, and it is extremely broad and extremely vague, and it's questionable whether someone could even comply with it. You know, there's 629 pages of appendices that Chase is being ordered to prepare a corporate representative to testify to other testimony from other cases that have completely unrelated to this case, testify to entire documents of cases or dockets of other cases that have nothing to do with this case. And the other thing that I would point out that this court has held is that, and I'll quote, the only way that a non-party claiming privilege may test a court's order other than by certiorari is to risk contempt citation, then appeal.
You're not claiming privilege here, Mr. Bowes.
It's not privilege, but it puts us
privilege here, but
it puts us in the same position. There could also be privilege that we don't know that arises yet. If
well, when it happens, you can assert it.
If I understand the court's position, I think that the case law suggests that if there is wide-ranging, categorically irrelevant subject matter that is being allowed, that in and of itself is irreparable harm, and that's what we have here. And the substance of our argument is why every area of inquiry in this subpoena is something that is necessarily categorically irrelevant, because it's something that this respondent does not have a right to assert at all. It's all in support of an affirmative defense challenging this endorsement. And as a matter of law, this respondent doesn't have a right to challenge that endorsement. And the court does not.
Suggesting that if this, because of the FERIA involvement, because generally the onus, the burden of proof is on the plaintiff to demonstrate standing, correct?
Correct, Your Honor.
So are you suggesting that because this went through FERIA, that the plaintiff here is totally relieved of that obligation?
Not at all. And
so if the defendant had not couched it as an affirmative defense, but could have just denied the standing allegations, wouldn't they still be entitled to do the discovery?
No, I disagree with that, Your Honor. And if you would give me a minute to address that, I'd be happy to do so. So the first reason that this respondent is categorically not allowed to question this endorsement is basic Hornbook contract law, which is an endorsement is a separate contract. It is an independent contract. It is separate from the note itself. The Hornbook contract law is that if you're not a party to that, and the borrower is not a party to that separate endorsement contract, they don't have standing to challenge that. And this court has excellent case law on exactly that. Now, I'd be happy to go through that point. The first being that that the endorsement contract itself, separate contract.
Let me interject here, Mr. Bose. You didn't mention to me, I don't think, whether you wanted rebuttal time, but you are down to 5 minutes, so use them as you please. But I just want to give you the heads up.
Oh, okay, I would like to preserve 3 minutes for rebuttal, Your Honor.
Okay, that's good.
And so what I would say on this question of standing, Your Honor, is that trying to challenge the validity of the endorsement is not synonymous with challenging the plaintiff trust standing. This borrower, this defendant can still challenge standing. Standing under this court's case law is possession at the time of filing that's valid with valid title on its face. It is not asserting an affirmative defense of forgery. In other words, to prove standing, you don't have to come in and prove that every endorsement on a note is not a forgery. You have to show that you had a note valid on its face at the time of filing.
I recognize that, but the point you were making is that they couldn't challenge it ever, even as in a defensive posture.
That is correct, Your Honor, because they are not a party to the endorsement contract. This is the basic Hornbook law, and I'll cite to Green Emerald Homes LLC versus 21st Mortgage Company, 300 Southern 3rd, 698. That's this court in 2019, referring to the Hornbook contract law rule that a person who is neither a party to nor an intended third-party beneficiary of a contract has no rights under the contract to enforce. And
well, but the point that what I'm saying is that, say you're at the first stage after the FREA involvement. You're saying that if the plaintiff came in and filed a foreclosure action and alleged that it had standing as the holder, the defendant could never, ever at that point say, well, I'm not sure that's true, that there was a valid endorsement.
If the question of the endorsement under FREA, and there's two different arguments. One is that the endorsement is a contract between the endorser and endorsee.
Contract rights. I'm talking about whether there was a valid contract, because there was a valid or invalid endorsement, and that the defense, not asserting any affirmative, right to affirmative relief, but if the defense says, wait a minute, that wasn't properly done, you're saying they can't assert that and do discovery on that point.
And the case that's directly on point to that, Your Honor, is this court's opinion in Wells Fargo versus Diaz.
Was that a non-party asserting that right before, that law before us?
Well, what it was in that case was a defendant like this borrower who was able to challenge the elements of the claim, but they weren't able to challenge the validity of a contract to which they weren't a party. In that instance, it was a subsequent purchaser trying to challenge the validity of the note. In this case, it's a borrower trying to challenge the validity of an endorsement contract, which is just the same, a separate contract. They don't have the right to challenge.
Your client's only involvement in this litigation is as a party who's been asked for discovery.
That's correct, Your Honor.
Okay. You are, I've talked you into your 3-minute rebuttal time. So I'll still give them to you if you want to stop now.
Okay, Your Honor.
Okay. Mr. Jacobs.
Thank you, Art. So may it please the court, JP Morgan Chase filed a petition for certiorari that I would agree with the court does not confer jurisdiction on this court. First, as both Judge Kuzam and Judge Northcourt have been clear on, there is no irreparable harm by asking Chase to testify about their investigation into these undated rubber stamp Washington Mutual blank endorsements. The only argument they're making is relevancy. That's not a basis for certiorari. Second, there is no departure from the essential elements of law. The question of whether Chase forged the Washington Mutual endorsement and fraudulently created the evidence of standing is relevant. As Judge Kuzam wrote in the Sorensen case, that is absolutely a defense that would not be frivolous to raise. It is an appropriate defense to raise based on an established body of law that goes back for 6 decades. So I think when you look at the just the jurisdictional issue, I think the In re Commitment of Sutton case really does make it clear that because the bank is not arguing any kind of cat out of the bag, privilege, anything that would cause irreparable harm under the body of case law, Lewis Tree Services, Herzog, Freeland, First Parity, Langston, it is well established that that they cannot seek certiorari review. And there are other DCAs, the third DCA, the first DCA, in the Cook and the Winkler case, that said there is no irreparable harm or departure from the essential elements of law to require a corporation to designate a corporate representative who is able to testify about matters known or reasonably available to the organization. Here, JP Morgan Chase has already represented in the pleadings that they have acquired information over the years regarding Washington Mutual's endorsement practices, and their representation is Washington Mutual endorsed all of the notes in blank, and it did so in offices that endorsed thousands of notes per day. Clearly, that is relevant discovery. I'm asking not for carte blanche discovery into irrelevant issues. I'm asking to challenge the statement that was made in the pleadings in this case by Chase. And under the Florida Supreme Court cases of Board of Trustees of International Improvement and Allstate versus Langston, you cannot seek certiorari. There is no jurisdiction, even if the discovery order is erroneous, even if it's irrelevant, even if it's overbroad. Certiorari is simply not available to Chase at this place in the proceedings. Now, I do take umbrage with the argument that Chase is making that a contract is the endorsement's a contract and cannot be challenged under any circumstances by a party. That is not the law in Florida. There is a body of law that they keep citing, which is an endorsement is a contract, and that's true. And in all of those cases, none of them are dealing with the question of a forged endorsement. They're all just dealing with people that are using endorsements in the ways that they were supposed to be used. I think one of the cases I pulled out was this Carrier versus Sears case that was in the footnote that Chase had put into their brief. And it cited a case from 1862 of the US Supreme Court that says an endorsement is a contract, and the contract of an insane person or one obtained by fraud or duress is voidable and not void. And that just shows that there is ability to challenge an endorsement. About who's insane, if it was obtained by fraud or duress. But we go a step further. It's not that the question of the US Supreme Court said it's voidable. These endorsements are void. And I cite the Sapp case, the Bird case, the Jamadas case. All say the law regarding forged documents is well established. They are void. So you cannot have a contract if Chase forged the endorsement of Washington Mutual and then come to court and say, there are some rights. I think, Judge Northcourt, you nailed it when you said this is not about contract rights. This is about whether a contract existed, whether there's a valid contract that existed. So clearly a forged endorsement is something very different from all the other types of cases that Chase has been relying on throughout this briefing process. And I think it's important to recognize, Your Honors, that when you look at the law that we have here in Florida that has been developed over decades, it's clear. In this case, the plaintiff replied to our affirmative defense that this was unclean hands and forgery, which is different from any contract rights. This is just saying, hey, there's a problem with this endorsement. It was not created correctly. It was created, as we said in Sorensen, that it was fraudulently created with the intention of establishing standing through improper means. And the plaintiff in the case said that we are simply unable to burst the presumption under 673.3081 and Bennett versus Deutsche Bank. So Chase is trying to make an argument that the plaintiff in this case is not arguing. Then you go through Sorensen, which talks about there is no indication that an amendment would be futile. And the evidence in which the bank relied to show standing had been fraudulently created and produced. Specifically, the bank added the undated endorsement, provided perjured testimony to falsely backdate the endorsement, and submitted a false assignment of the note and mortgage to support its timeline events, which is the exact argument we're making here on behalf of the Lofgrens against Chase. And there is a established body of law going back to Ederer versus Fisher in 1965, was pre the enactment of all of these of the UCC on Article 3. But what it said is once a party challenges the signature on a negotiable instrument, there is a statute that governs that process. Once it's challenged, they have the right to present evidence. Once they present evidence, then if they're sufficient to burst the presumption, the burden shifts to the plaintiff to prove it's not a forgery. All of this has been litigated just recently in the Lovett case. The Third District Court of Appeals, we litigated. Mr. Bose and I went to the third DCA in Chase versus Lovett, and Mr. Bose made the exact argument that I was making to the third DCA, that I have to, under 673 and Bennett and Schwartz and all these cases that say there's a proper procedure under the statute to challenge an endorsement. And what you see is that they made that whole argument, and the Third District Court of Appeals said that this is proper discovery that I should be attaining pre-trial, and which is what I'm seeking to do. So when you look at the law that we have here, and there's no shortage of cases that have dealt with this issue and said exactly what I'm saying. Bennett, Schwartz, Rivera, Centurion, Barson, Ray, Madura. The effect of 673.3081 presumption is to require the party challenging the signature to produce evidence supporting a finding that the signature was forged or unauthorized, which is exactly what I'm limited. I'm not even asking for documents in the subpoena anymore. The subpoena simply says, Chase, come testify about everything we know, this investigation you've done into these WAMU endorsements. And when you look at what we heard from Judge Karras from the U.S. District Court of the Southern District, he questions whether there should be a presumption anymore, because all this information is in the possession of the banks. They know what happened with these endorsements, and if they're called out to answer the questions, they're the ones that have the information. But if you look at UCC Common 1, it makes it clear the purpose of this statute is to give us, once I specifically deny in the pleadings, now the plaintiff has notice of the defendant's claim of forgery or lack of authority as to a particular signature. And that gives the plaintiff an opportunity to investigate and obtain evidence. So for Chase to come to court and ask the court on certiorari to say, wait a second, there's no way that we can do anything here because the law is well settled as a matter of law, I lack standing. They don't have a single case that says that. And what we do know is that there was just a federal whistleblower case. I was the relator on it in front of Judge Aileen Cannon on February 24th, 2022. She went through the allegations that were raised, the evidence that was presented, and talked about the fact that there was fabricated and coached testimony, that there was a fraud scheme, that there was a circumstantial evidence supporting the credibility of whether the fraud scheme occurred. And this is not just, when you take it into the big picture, the U.S. Senate Banking Committee in February of 2022 sent a letter from Senator Sherrod Brown, from Elizabeth Warren, from Robert Melendez, Tina Smith, Chris Van Hollen, and Senator Raphael Warnock, sent a letter to JP Morgan Chase's CEO, Jamie Dimon, saying, wait a second, we find that you violated the government's, the CFPB consent order, that the nation's largest bank with over $3.2 trillion in assets has renewed its predatory practice of robo-signing evidence for credit card cases. We're saying that they're doing the same thing for foreclosure cases, that they robo-signed, they took out these rubber stamps undated and put them before the courts, and have now given testimony, which Judge Cannon says is clear there's a problem here. And now their argument is, on certiorari, you should rule that nobody is allowed to challenge the use of fraudulent evidence. And I would just conclude on U.S. versus Olson. It's a Ninth Circuit case in 2013. Talks about when judges allow parties to prosecute their cases using fraudulent evidence, such behavior erodes the public trust in our justice system, chips away at the foundational premises of our rule of law. And when transgressions are acknowledged yet forgiven by the courts, we endorse and invite the repetition. What we're dealing with here, Your Honor, is a very simple question of due process. It is in the Fifth Amendment. No party shall be deprived of life, liberty, or property without due process of law. We were getting due process of law in the trial court. He ordered the deposition to go forward. This idea that because there is some act or omission that now we have to go to FAREA and let FAREA deal with this is simply not true. The issue that comes down here is FAREA is if WAMU did something wrong. We're not saying WAMU did something wrong. We're saying that Chase, long after the FDIC was involved, says that they did something wrong, that they took these endorsements and fraudulently created them, presented them to courts across the nation, including in this case, as their evidence of standing. The only evidence you have of standing is this endorsement. That's what they're going under. That's their whole case. And if the endorsement is invalid, it's not proper under the statute 673-081, then they don't have standing, and it would be a violation of due process to allow the foreclosure to proceed forward. So what we're looking at here, Your Honor, in the Olson case, what they talked about was, you know, it was a bigger case that we're talking about this problem of Brady violations happening across the country. And what they said was, you know, there's all this misconduct in the prosecution of cases, and it was determined, quote, only judges can put a stop to it. And that, respectfully, Your Honor, is what we are asking the court to do in this case. Clearly, there's no certiorari review. There is no basis. There was never a basis to say that we were asking for carte blanche discovery about irrelevant material. That was just not just not fair. That's not true. That's not what we were asking for. If you look at the subpoenas that we issued, the order that was originally granted was a subpoena that had more areas of inquiry and had a whole set of document requests that were all granted. But when we served the subpoena on Chase, just to make sure that we could get to the heart of the issue, which is just tell us what happened with these endorsements, you've already given testimony in multiple cases pursuant to multiple court orders. And that testimony appeared coached and conflicted with the testimony of Barbara Hinman, who said, I was in the room where these notes were supposedly being endorsed according to Chase, and it was a nice, quiet office environment. So we are here in this case trying to get the same evidence that Chase has already given pursuant to multiple court orders. And for them to say, you don't have standing to challenge the endorsement because the endorsement's a contract is creative, but it's not the law. And because they now know we've given them this law about the forgery, a forged endorsement is void. Any forged document is void. There is a lawyer right now from Pasco County who's serving time in prison because he forged endorsements to beat Bank of America in a foreclosure. That is exactly what the law says. Forgery is actually a felony. You're not allowed to do that. So is perjury. So respectfully, what we would suggest is the court should clearly deny certiorari relief, first because there's no jurisdiction. But I think that it is important to address there are no attorney's fees for this contract, for this dispute, because we're not in contract with Mr. Bose. We have made a request for fees under the court's inherent contempt powers. I believe that if you look at the law and you look at what we've presented.
Let me ask you, Mr. Jacobs, you said you made reference to fees. I had the opportunity to review it. You basically make a claim that in a very generalized fashion, pursuant to the terms of the note and mortgage at issue, you don't mention any specific, the statute and the rules require any specific grounds with which is based and I just see that it does not attach any supporting documents, doesn't specify which term triggers entitlement or even refer to which paragraphs that you're containing them.
Sir, that may be an oversight. In the brief itself, I asked for fees, the court to issue whatever it deems meet and just under these circumstances and under the court's inherent contempt powers or the terms of the note and mortgage. This was originally a Chase mortgage, it was originally a Chase case, and then they sold it to somebody else. And now Chase is back saying, you can't ask us from what happened to that note, whether we put the endorsement on sometime between 2008 and 2014, when there clearly is a good faith basis to seek that information. And they've already testified about that in multiple times. So I think that because we're dealing with a very unique situation where Chase is suggesting that that the law is well settled, that everything I've just told the court is not true, and simply I can't challenge any of this, is something that I shouldn't be here making this. I shouldn't have to be here making this argument on behalf of the Lofgrens, and they would be entitled to attorney's fees if the court felt that what was happening here was really Chase coming into the court and saying, please, 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 on certiorari, declare forever that the defense of the endorsement is not authorized or valid or was forged, is simply unavailable in a foreclosure case. And that is only because we have evidence that Chase forged the endorsement in this case. And we are presenting that as a defense in the case, and they don't have any meritorious defense to that. And if we're talking about, this isn't just about a contract, right? This is about unclean hands. This is about the integrity of the judicial process. This is about the integrity of the way we practice law. We come to court and we present the law correctly. We present the facts correctly. And if we don't do that, there's supposed to be consequences for that. And I just submit to Your Honor that we're beyond. They've never once even addressed the Sorensen case that Your Honors, Judge Kuzam and Judge Northcorp it was a unanimous opinion that said, I'm allowed to raise the defense that the evidence of standing was fraudulently created, specifically the endorsements and the assignments were fraudulently created, which is exactly what we're dealing here. And Mr. Bose is the lawyer who did not disclose to the court that he just went in front of the Third District Court of Appeals, making the arguments that were the true arguments. And the Third District Court of Appeals agreed with me that I'm entitled to this discovery, just suggested it needed to be done pre-trial. So now for them to come before the court without addressing that and suggest, as they said, as a matter of law, we cannot raise this defense that you are not the holder of a note because your holder status is based on the endorsement and the endorsement's a forgery. And that is not the law. And yet they forced me to be here today to make that point. And they don't have any jurisdiction to be here because we're talking about the certiorari review. There's no basis for them to be not giving the testimony that they wanted to get, that we were asked to give. So all of that, Your Honor, I think comes to the ultimate conclusion that the court should make it clear. This is not a proper certiorari review. There's no jurisdiction. What you're asking for is clearly not appropriate. And the court should also make it clear that the body of law that you are asking the court to reject and that you're suggesting is well settled is not, that is not what the law says. And here's what the law says. And I would ask that the court consider whatever the court deems reasonable, meet, and just in this unique circumstance, because we're talking about the nation's largest bank with $3.2 trillion in assets that the U.S. Senate Banking Committee is currently investigating for robo-signing evidence in credit card cases. And yet they are doing it again here in these foreclosure cases and raising arguments that are clearly not what the law or the facts suggest.
Okay. Thank you, Mr. Jacobs. Mr. Bose, you got 3 minutes.
Thank you. So the point is, Your Honor, that there is no case that has directly addressed, as applied specifically to an endorsement, the standing of a borrower to challenge that endorsement. Mr. Jacobs acknowledged that endorsement is a separate contract. The cases that have allowed it de facto.
Mr. Bose, I think you're hard put to suggest that we should exercise our certiorari jurisdiction to declare that this discovery order is a departure from the essential requirements of law, even if you were in a position to assert the standing of the other party.
Well, and I'll read you, and if the court doesn't want to hear that, though I think that is clear.
Typically are discouraged from making law in a certiorari proceeding in Florida anyway.
Yeah, and I think what Judge Northcutt, as I understand, and I tend to agree, for us to grant cert is when we say there's a clear departure of law. How can there be a clear departure of law? There's no cases right on point. Well, stand for the proposition that you want us to do. And as I suggested earlier, would be the very first case ever to say that this defense fails as a matter of law. As I understand, that's what Judge Northcutt is coming from.
Well, and beyond that a non-party to the lawsuit can assert that as in order to avoid giving discovery that is relevant to the defense.
And my argument is that it's not relevant and that this law is clear. My point is the principle of law, which is that a non-party to a contract does not have standing to challenge that contract, including the existence, whether it's void. That law is very clear, and this court applied that law in the Diaz case, exactly analogous to this, except that party was challenging the actual note and saying it was a forgery, and the court said, no, you can't do that. That defendant, if they could have said that, it would have voided that mortgage. They wouldn't have been foreclosed upon. And the court said, no, you can't do that because you're not a party to it. That law is very clear. The only thing that it hasn't been applied to is an endorsement contract. which the respondent admits also is an independent contract, and the borrower is not a party to it. So it's exactly the same thing. All of the cases that have de facto allowed a borrower to challenge that endorsement contract did so with no one raising the issue. We cited the Supreme Court case that said if a party doesn't raise the issue and the court doesn't address it, those cases are not precedent. So what that leaves us with is the Hornbook contract law, that if you're not a party, you don't have standing. And so that is what the law is.
Here's the problem that I see, and certainly as a non-party, you don't have any greater right to certiorari than the party to the case does. And if the plaintiff in the case is arguing this and file a motion to dismiss, saying it was denied, the plaintiff in the case would have to wait till appeal from the final judgment to bring this up to us. I don't know why you get to bring it up now.
Well, we have no other opportunity to appeal, Your Honor.
Yeah, but they would still, the plaintiff in the case would be, couldn't come up to us on cert and say, we're not going to give discovery on this.
No, but they could appeal clear error at the end. We'll never have an ability.
But would have given discovery in the meantime. And that's all you are being requested to do, is to give, not requested, compelled to do, is to give discovery.
If I could, and that was the issue of the substantive right or the material. If I could just read one quote.
Yeah, and then wrap it up. So just.
Okay, thank you, Your Honor. This is from a Seventh Circuit case that is addressing the Faria argument. And I want to read you what the allegations are that the court considered, which are the identical allegations here. And I quote, and this is Maines versus Citibank, 852 F 3rd 669. The allegations are, Maines seems to allege that Riley, a former vice president of WAMU, fraudulently endorsed his note, even though she was not validly employed, parentheses, by WAMU, question mark, as a vice president, question mark, at the time of the alleged endorsement. The court goes on to say, or perhaps a better way to characterize the implication in this complaint is that Riley did not endorse his note and that her purported endorsement was a forgery. So the allegation that that endorsement on a WAMU note that was an asset in an institution under the receivership of the FDIC, which is the exact allegation in this affirmative defense, the same claim. And here was the holding from the Seventh Circuit Court of Appeals.
And did the Seventh Circuit Court of Appeals say a non-party to the lawsuit could assert that to avoid discovery? I don't think so. And I tell you what, whatever they say, I don't think you can do it in Florida.
I think that dealt with the plaintiff. It was a plaintiff. That was a party. It was a not. It's. I agree with Judge Northey. This.
I mean, I honestly.
But this went to the.
Why you think your client can come and assert a challenge to a defense in order to not give discovery on it when you're not a party to the case?
Well, the Faria statute, Your Honor, goes to the court's jurisdiction to consider a claim. In this case, it's the same claim. It's asserted as a defense.
It's a defense.
But the defense is asserting the same thing. It's trying to invalidate an asset.
No, they're not trying to invalidate anything. They're just trying to say you can't. The plaintiff in this case can't proceed against them on the basis of it.
Well, Mr. Jacobs keeps repeatedly saying it's void. He's saying if it's forgery, it's void.
But now you're getting into some ad hominem arguments for why you think we have cert jurisdiction to let you avoid discovery when you're not a party to the case. You have no standing to challenge their affirmative defenses. I just don't get it. Tell you the truth.
Well.
But you used up your rebuttal time.
Thank you.
And I will say you performed well under fire. But with that, in order to leave our courtroom, you click the leave button on your Zoom screen, this little red button, and you'll go away.
Thank you, Your Honor. Have a wonderful day.
Thank you to all of you.
Thank you all.